Hello, good afternoon, everybody. In my presentation, I would like to show you the decisions of Polish Constitutional Tribunal, which refer to bioethics and medical law. The first decision concerns the consent to medical treatment granted to the minor. The second one refers to the dilemma of the medical conscience clause. At the first glance, the issue may be joined with public law. But the deeper investigation shows that the issue shows the civil consequences of the problem. And we'll go to this point later. At the beginning, I would like to say a few words about the way the Polish Constitutional Tribunal assesses the constitutionality of the domestic norms. The reasoning of the tribunal shows in this way strong similarities with the way a European Court of Human Rights assesses the conventionality of domestic decisions of states courts. The basic element of Polish tribunal reasoning is the process of weighing the values, many times also arising from European convention standards. For example, the tribunal is weighing health and public order and giving the stress on the argumentation method of interpretation. And when it comes to the rights and freedoms of a person, the formal way of weighing the values is by proportionality test, which is derived from Article 31 of Polish Constitution. It should be considered whether it meets formal criteria. Proportionality must fulfill a premise considering a restriction which may be only introduced by a statute. In the case of a reply in the affirmative to the basic question, the so-called test of proportionality should be carried out, including three premises: effectiveness, necessity, and proportionality in the strict sense. That is how Polish tribunal interprets and weigh values which are somehow in collision, and in cases which I would like to tell you about, this weighing is also may be remarked. So now let's check the reasoning of the tribunal in the cases mentioned above. The first one, consent to healthcare services granted to the underage patients. Polish tribunal considered the constitutionality of the provisions which do not grant underage patients the right to participate in decision making if they do not reach the age of 16. The tribunal had to examine whether the formal criterion, in this case the age, used by the legislator, does actually restrict the fundamental subjective rights of underage patients, especially the right to privacy, especially the right to personal inviolability and security, and the respect which can be found in the Constitution referring to the degree of maturity of a child as well as his freedom of conscience and belief. And also, as I mentioned, the right of legal protection of his family life, of his private life, which is protected by the same section of Polish constitution. And the tribunal assessed that, as I mentioned, regulations were constitutional. According to the judgment, the constitution does not require that the views of a minor considering the healthcare matters should have any direct legal effects. They also contain no detailed, the constitution does not contain any detailed information about the minimum age at which the views and actions and the way, the proper way of dealing with the body of a child should trigger legal consequences. The judgment of the tribunal had some external arguments derived from case law of European Convention for the Protection of Human Rights and Fundamental Freedoms. What is more, the tribunal referred to the domestic constitutional system, especially relevant previous decisions of the Constitutional Court, as well as arguments based on jurisprudence of Polish Supreme Court. And well, the second remark of the tribunal was about the motion of liberty. The tribunal considered that infringement of personal liberty and personal inviolability of a minor under 16 cannot be treated as, firstly, as a value which is absolute, because there are many values which may be weighed and may, let's say, win in this collision. And what is more, the tribunal found out that this minor who is under 16 in such an important thing as medical treatment, serious medical treatments, is not, in general, is not able to assess the situation objectively in a right way. Hence, the regulation remains with a remit of a legislator. The awareness of a patient remains to the discretion of medical personnel assigned to carry out core healthcare activities. For example, admission to hospital, the procedure, examination. And the tribunal found out that focusing on this consent made by a minor could lead to much more serious infringements of patients' rights than those which, according to the applicant in the case, occur in the context of currently binding provisions. And now, civil implications. Because the problem, whether the minor may decide about his medical treatment, refers basically to the public law, to the relations between state and person, because the state in some way limits the right to decide on their own way about on life or on legal goods. But this problem refers to the more general problem of consent also in civil law, because the reasoning concerning the ability of a person to decide about his health during medical treatment may be used in civil relationships. I mean the limits of freedom of contracts using the standard from the case above. When we think about the limits to which contracts may be done by parties freely should take into account this case and consequences which are pointed out by the tribunal. Examples: for example, tribunal does not directly say about it, but we may think that, for example, the contract with the minor concerning making a tattoo, or including contract of voluntary sterilization or some plastic surgeries, may be, using the reasoning of a tribunal, treated as invalid in civil terms. Such contracts are invalid because there is no breach of personal liberty in this place. Liberty not treated in an absolute way, and also since the minor is not in general aware of consequences and significance of his decisions. So it's why the public law implies some civil problems and civil solutions in this case. And the second one, the second case which I said we'll discuss, is the one concerning medical conscience clause. In the judgment in 2015, the Polish Constitutional Tribunal examined whether the Polish provision violated freedom of conscience in the regard that the statute has obliged a physician, quoting the conscience clause, to provide a patient with information on actual possibility to obtain a given service from another physician. The tribunal held that the freedom of conscience enables to invoke the conscience clause, and as a result ensures the right to refuse to perform an act contrary to one's conscience. What is more, this clause of conscience allows not only to refuse to provide the medical treatment, but also to refuse to provide the information about possibility to obtain such a treatment. In this judgment, one may find the statement according to which the duty to perform the conduct, which indirectly leads to an unacceptable ethical effect, and in particular protection from coercion to cooperate in achieving an immoral goal. So according to the tribunal, the right which allows to use the conscience clause stems directly from the concept of freedom of conscience. It is not the source of this clause is not statute, but the freedom of conscience which has a source in the Constitution and in the case law of European Court of Human Rights. The tribunal recalled the judgment of European Court of Human Rights in the case Bayatian v. Armenia, and found that conventional standards according to which the democratic states should respect the interest of an individual whose motivation was not arbitrary but very religious one. Due to this, such an interest deserves the protection also under Polish constitution. Here you can also find that using of the conventional standards of European Court of Human Rights is basically on the level of argumentation. And then, again, civil implications. This case also shows implication to the private relationships between equal parties. In civil law, judgment which shows that one may use the clause of conscience evokes such questions which are related to civil law. Does the conscience clause apply also to other legal relationships, not only in medical situations, but also, for example, may the teacher or journalist use the conscience clause? But furthermore, as to civil cases, may I refuse to perform the service based on the civil law? May I breach the contract because of my conscience and use the conscience clause derived directly from Constitution? For example, may I refuse to print the papers if I don't agree with the printed content in it? The tribunal noticed that the conscience clause is not derived from any statute. It is the most important part of this case for our situation here, directly from Constitution. So we cannot exclude the potential use of conscience clause in civil relationship. We can see then that the principle, for example, pacta sunt servanda, or the principle of safety of trading is the value which may be treated as less important than the freedom of conscience, and the application of this case in situations which were not the scope of reasoning by the tribunal, but give some effects, indirect effects on the relationships between private parties. Thank you very much.